So we've come to that moment of, it's been a great 3 days. I can't believe we're already here. Oh. Thank you, Kate. I know I asked you to clap loud, but I really appreciate it. So thank you. Two things. We've got a plenary. I'm going to properly introduce Justice Karakatsanis momentarily, but we have a bit of housekeeping and a couple of things to do ahead of time, and I've checked in with Her Honor just to, and she's given me this indulgence, so thank you. I also want to notice there's a cameo appearance in the room, which I was not expecting. It's not every day that the Chief Justice of Ontario rolls in unexpected. So we'll try and find a plate of food for you, Chief Justice. Okay, before we get to the plenary event, and I know there are folks who are traveling, so we'll keep things moving. 4 things in my comments now. The first thing, next year, this conference restarted in 2002 online. Last year, Emily and her team hosted it at UC Irvine. This year, we've hosted it at Osgoode here in Toronto. And so the question is next year. Last year, there was a sort of a big reveal and the kind of the passing of the torch happened. This year, that's not happening. There was a plan that has fallen through. Emily and her folks and her team are working on it. I know we're in good hands. I'd say we would be delighted to run it back next year, and I would be, quite frankly, but I think it's good for the conference, good for the group to spread it around, and that's the whole idea of this. So stay tuned. If people have particular ideas, feel free to be in touch with Emily. I did check with her, but I know she's working on it. Second, publications. One of the plans I had that I just failed to get to was, are we going to do a conference proceeding, and what are we going to do with the work and what have you? And the answer is we're not totally sure, but 2 things. One is I'm hoping that we will have at least a publicly accessible platform for the materials, like the PowerPoints and whatever materials we've got so far that will live on, whether it's on the conference platform, whether it goes to Osgoode Digital Commons, whether it goes to the Winkler Institute. I'm not sure, but we'll try and figure that out soon so that you have access to those materials and can share those materials. Whether we do a conference proceeding of peer-reviewed papers that people are going to continue and do to write, we may do that as well. I don't know. I don't want to overpromise, but it's certainly on our mind. But at least we will get the publicly accessible stuff up somehow and get that done. Third, the issue of diversity. I think this conference has been I've been delighted with it. The one thing I think, though, that we could do better is have the room reflect better the global community that we are working in and seeking to serve in all its ways, from regional, cultural, racial, all ethnic, all sorts of backgrounds that are working directly in and for the justice community. I think we could do better. I think we could have done better, but here we are. By one example, we did with Matthew Burnett's help, we did apply to the Mott Foundation and actually got funding from the Institute of International Education for travel grants. And so we did think ahead. We successfully got that. The problem is that we got it this week. So I realized that's totally unhelpful. What I'm trying to do, and that's not their fault. We did apply ahead of time, but these things take time. So we're learning. So we'll figure out whether we're going to try and make that available back end to folks who really need it, or whether we roll it into next year's conference somehow. We need to talk to the Institute and we need to figure it out. But in addition to travel funding, I think it's just through our networks and what have you, that we really need to double down on this issue because we've got to reflect the communities that we're serving and working with. Fourth, and finally, the issue of collaboration has been a theme in some of the panels. It's a theme in some of your work, which fits with systems design. It fits with all sorts of stuff. And for those who have been working in this either just for 5 minutes or for 20 years, the issue of not reinventing wheels, the issue of how do we coordinate and work with people, the ideas of we know people in different countries are doing stuff. How do we build and collaborate is not a new concept, obviously. And I've often thought about it as this idea of that, those paint by numbers pictures where, you know, you're going to be painting one little thing, but it's a better picture if we sort of have a bit of a global sense, and no one's going to tell you what to research, but if your research fits somewhere, all of a sudden we have a more powerful picture if we start that kind of working together approach and that collaborative approach and learning from each other. This conference is a version of that. But I know our colleagues at the American Bar Foundation, Matthew, and then the person who I'm going to introduce is just going to speak for a minute or two on this. Probably, if I think of all of the folks who have been working on access to justice for a long time, and there are many of them, some in the room, my colleague Ab Curry, who's been doing this stuff for years. But probably currently, we would all agree that it's always hard to pick a favorite among favorites. But I think Professor Rebecca Sandifer is really at the top of everyone's list on someone who's thinking deeply and critically about access to justice, community-based access to justice, sophisticated research, empirical research. It's the whole package. And so rather than me talking about Becky, I'm going to hand the microphone over to Becky on this issue of collaboration.
Thank you, Trevor. So then my best moment is to get you all to thank Trevor and the organizing team, Emily, Hugh, everybody here who made this incredible event possible. Thank you. Thank you. And this event is actually the descendant of earlier events. I wasn't at the first one, but I bet Ab was. So this event is a manifestation of something that ran out of the University College London, which was a manifestation of something that ran out of Legal Services Research Center. And what happens is people retire and they move on to other tasks, and institutions that exist for a while then go away. So one of the things we try to think about is how can we have some continuity and resilience of the community of people who are doing this stuff, so we can still have convenings, because no one wants to do convenings for their entire life. They want new generations to come in and do them. How can we have a community that can take this forward? And so I just want to offer up two things that come from the ABF, the American Bar Foundation, right now that we would love to have you join us with. So one is something really simple and totally old school for those of you who have email. It's a listserv. And all it does is connect people who are interested in empirical research on access to justice. So it's a place where you can share your events, you can share your new findings, you can ask if anyone knows about any kind of research about whatever, or who would fund what. It's a way for us to talk to each other when we're not in the same room about the work that we do and how we can move it forward. The other thing we would invite you to engage with, and this kind of speaks to Trevor's point about the very diverse places and people who we want to connect to justice, and ways to think about how to do that. At the ABF, we have a project called the Justice Data Observatory. And what that project tries to do is talk to people at the global conversation level and then at country levels about, if we care about people-centered access to justice and we believe that it causes some things to happen in the world, like it reduces poverty, or it creates distributed growth, or it makes people able to be more democratically engaged, how would we know? So what research exists on that in different kinds of contexts where we might want to know about this, particularly the global South, where we have there's less investment in doing the research, but there's also less researchers and there's also less research. So if you go to the American Bar Foundation website, you can see the early publications from that project, and we would absolutely welcome your engagement around it. If it's a tool to you to show that what you're doing is contributing to a bigger conversation, if it's a tool to you to motivate other people to pay attention, or if it's a tool for you to tell us that we're not thinking about something right and we should think about it differently, or if you just want to engage around it, we welcome all of that. So that's all. Thank you, Trevor, very much.
Thank you, Becky. Okay, let's get right at our next event, which is our final plenary for the conference. And I'm so delighted to welcome the Honourable Justice Andromache Karakatsanis from the Supreme Court of Canada. Justice Karakatsanis was appointed to the Supreme Court in 2011. She was appointed to the judge of the Court of Appeal of Ontario in 2010 and the Superior Court of Justice in 2002. Many judges have different kinds of backgrounds and they bring all sorts of perspectives, obviously, sometimes from practice, sometimes from the public service, sometimes from different. Justice Karakatsanis brought and brings multiple different kinds of hats in private practice, in different kinds of practice areas. And then huge contributions in public service, including as the Deputy Attorney General from 1997 to 2000, and then Ontario Secretary of the Cabinet and Clerk of the Executive Council from 2000 to 2002, being the province's senior public servant. So brings a massive experience, not just from the judicial side, not just from private practice, but also from the public service, which I think has informed, at least my understanding is, lots of her work. There's so much I could say about Justice Karakatsanis, and I'm not going to. I promised I would keep this short. But a couple things. And she may talk about this. One of the things in the country that we have here is the National Action Committee on Access to Justice in Civil and Family Matters. And I can't help but give a quick shout out to Diana Lowe, my friend and former colleague at the Canadian Forum on Civil Justice, who was dramatically instrumental in the starting of that organization many years ago. But Justice Karakatsanis is the chair of that. And so she doesn't just sort of think about access to justice. She doesn't just do it in her day job, but it's also part of her heavy volunteer activities that you really care about. So we're so grateful for that. And that really brings me to essentially two things that bind our three keynote speakers, two of whom are in the room. A tireless commitment by our current Chief Justice of Ontario, by our current Attorney General of Ontario, and Justice Karakatsanis to not only the idea of access to justice, but trying to improve it. And I think you've heard from the three of them in different ways, or you will have heard from the three of them in different ways, that is true. The second thing that brings them together that I think is probably the most important is they're all graduates of Osgoode Hall Law School. So we could have just started and ended with that. But with that, I guess the only other thing I'll say that I can't help myself, like with the Chief Justice of Ontario, speaking as a personal moment, I was also delighted to be present on stage when we were able to give Justice Karakatsanis an honorary doctorate at York University, which was a really special moment as well. So now I'm kind of torn between the two of you, but you're both my favorite. Anyway, Justice Karakatsanis, thank you for coming.
Thank you, Trevor. You promised to keep it short, though.
I did.
Well, good day, everyone. It's quite exciting to be part of such an important and inspiring conference. I can still feel the energy, even though we're Friday afternoon, and this is what's holding you back from going home to your homes, or hopefully not to the office after this. C'est un grand plaisir d'être ici avec vous. Je suis ravie de me joindre à cette communauté motivée, cette communauté mondiale qui défend l'accès à la justice, qui se réunit pour discuter de la manière dont nous pouvons renforcer la justice, l'état de droit qui fonde la démocratie et instaurer la confiance du public dans la justice centrée sur les personnes. Because access to justice is about the kind of society we want to live in. It's about the rule of law, essential to democracy and to peace. I mean, I don't need to tell this group, but justice is a common good, and it's a basic human need. It is fundamental to the pursuit of a good life. So I have had the privilege to work in the justice system in different roles and from different perspectives. As a student at a poverty law clinic, yes, Parkdale, as a lawyer in private practice, a tribunal chair, deputy minister of justice, and a judge of 3 levels of court. I've had the privilege to work in the justice system in different roles and from diverse perspectives. And now, as the chair of the National Action Committee on Access to Justice in Civil and Family Matters, I am grateful to work with many members of the broader access to justice community across Canada and beyond. So my experiences during my career have made me a strong advocate of people-centered justice. They've also showed me that embracing new perspectives is not always easy. I began my time in public service as a tribunal chair and adjudicator in the administrative justice system. I was involved in the founding of the Ontario organization and vice chair of CCAT, the Canadian Council of Administrative Tribunals, developing codes of conduct, model rules of procedure, training modules, while also working to introduce mediation and statutory procedure reform. It was a heady time. I believed that administrative tribunals offered an accessible system to provide everyday justice to many Canadians. And yet, even at its best, tribunals, administrative tribunals, are still often seen as second-class justice. As a senior public servant, I was most concerned about the institutions of justice, with their accountability, with their capacity to meet the needs of the public. And of course, I dealt with substantive legal rules, legislation, and regulations, which, as you know, can transform access and justice. En tant que juge, je valorise la justice plus accessible dans les cas individuels. J'ai toujours essayé de mettre les personnes à l'aise dans la salle d'audience, d'utiliser les processus plus efficaces et de rédiger des motifs clairs et simples afin qu'elles comprennent comment la justice est rendue. Now, as a judge of the Supreme Court of Canada, I think of what access to justice means in the context of every case. In the 2014 decision of Reiniak and Malden, I wrote that ensuring access to justice is the greatest challenge to the rule of law in Canada today. I called for a culture shift to promote timely and affordable access to justice in our justice system. That was 10 years ago. Reiniak remains one of the most cited decisions of our court. But with every case I deal with, I think about what are going to be the practical effects, what are going to be the real impacts on people. I have to say that despite having spent decades working to further access to justice in many roles, it was only after joining the National Action Committee and reading Trevor Farrow's amazing book on access to justice that I realized I had viewed justice and legal reform through the perspective of a professional working within the institutions and systems of justice. I now strongly believe that to effect a real culture shift, it's essential to view justice through the eyes of ordinary people, often vulnerable, and to engage them in that work. Je suis convaincue qu'un véritable changement de culture demande que la justice soit définie par ceux qui cherchent à résoudre leurs problèmes juridiques et de les impliquer dans ce travail. Part of the shift in perspective is realizing that most people want as little to do with the legal system as possible. Their goal is to never deal with the laws and the institutions we're trying to reform. Mais la vie et les circonstances les obligent à faire face au système judiciaire. A people-centered vision for justice means going beyond our traditional institutional perspectives and biases, putting people at the center of our work towards legal reform. It means helping Canadians before they enter the legal system. We need more creative ways of avoiding legal problems so people need not access those institutions. This includes empowering them with information and resources to understand their rights and responsibilities. I know that's what you've been talking about. It feels like I'm preaching to you, to the choir, singing to the choir, but you can't underestimate, I think, the importance of repeating these things and reminding ourselves that everything we do every day impacts real people. At the NAC, the National Action Committee, we are advocating for that change in perspective. that way of thinking, which expands access to justice beyond access to lawyers and courts and tribunals, to focus on the legal issues of people as they experience them in their everyday lives. Placing people at the heart of justice requires a common will to challenge the status quo and an action-oriented response. We learned at the OECD Roundtable in Ottawa this past month that Canada is one of the few places with a National Action Committee and is a world leader in providing high-level commitment to a people-centered perspective on justice. You even get the Chief Justice of Ontario making a second appearance at this conference. So we have been reflecting deeply about the Action Committee's contribution to our shared vision of equal access to justice for all. The NAC, National Action Committee, the NAC members are representatives from justice sector organizations, governments, regional committees, and equity-seeking groups from across Canada. Among our individual members, we find service providers, researchers, donors, but as an overarching national body, the Action Committee is none of these. So what do we bring to the table? Well, we play a critical role as catalyst and convener, as a national voice that can inspire and amplify the work that its members are doing and facilitate the sharing of best practices and lessons learned. There is a power in the breadth of our membership that allows the NAC to exchange ideas and share experiences and to do things as a collective that we cannot do individually. Our unique structure brings with it a responsibility to rigorously pursue that transformation and culture change. Le comité d'action vise à montrer l'exemple et servir d'ambassadeur pour une approche centrée sur les personnes. Nous cherchons à amplifier la voix des Canadiens afin de comprendre leurs problèmes quotidiens. Et nous chercherons à initier les discussions et défendre de nouvelles approches. New initiatives may include promoting diverse models of legal assistance, championing a range of dispute resolution options in the community beyond the existing systems. We're also looking to advance interdisciplinary collaboration, including among justice, health, and social services, to break down silos and support better outcomes for people across the country. Le renforcement de nos liens avec la communauté internationale pour l'accès à la justice est une de nos priorités. Nous espérons contribuer de façon substantielle au mouvement global afin de promouvoir la justice centrée sur les individus. And this includes furthering the UN's Sustainable Development Goal 16 to provide access to justice for all. With all of these initiatives, the NAC is engaging directly with service providers, professionals, and those representing vulnerable people at the center of justice, who are most impacted by insensitive processes and unjust outcomes. We have some ambitious plans. But any plans to further access to justice requires evidence on which to base our understanding of the challenges and needs of people and particular communities. We must continue to ask what data we need and how we can evaluate it. Inevitably, what gets counted will guide our actions, so it's critical to count what matters. We are thus keenly aware that research, measurement, and evaluation underpin a people-centered approach to access to justice. We aim, for example, to develop performance measures to assess the Action Committee's own impact and support the development of performance tools for our partners. We will support analysis of the Justice Development Goals and work to encourage more research to help fill gaps in our understanding and to support evidence-based responses. Like the OECD, we will take a wide-ranging view on how to assess the true costs of our legal systems, including the costs of what a failure of access to justice means. In family law, for instance, what are the broader impacts when a dispute cannot be effectively resolved, both for the individual family members and for society at large? Determining what we research, what data we collect, requires that we think deeply about what access to justice means for people and for the society in which we live. Access to justice permits people and their communities to flourish in a stable democracy grounded in the just rule of law. It's so much more than a proportionate process and a just result in a tribunal or court. Justice is a common good and a basic human need. Accessing justice is also more broadly ensuring that legal problems do not get in the way of a good life. And I thank Trevor again for that powerful idea. Je crois qu'ensemble, nous pouvons changer les paysages de ces pays pour le meilleur. We're all dedicated to a just society that contributes to a better life for all, so that no one is left behind. Together, we can meet our common goal of achieving just solutions for everyone, guided by the people we serve, les personnes au cœur de la justice. Thank you, merci. I look forward to our discussion. I should note that Trevor has been with the National Action Committee from the very beginning. And when he was appointed dean, I told him he couldn't leave.
Well, thank you. Wherever you're comfortable. Thank you, Justice Karakatsanis. You've kindly said you'll stay and have questions and we can get in. So the idea, I think, is to stick with our theme for the whole week, flip the room now and have a bit of a conversation if people have questions. I've got a million questions, but I've been crapping on all week. So are there questions and things you'd love to ask Justice Karakatsanis? Or comment.
Or criticism.
And I won't throw him, I haven't asked him this, but the Chief Justice of Ontario is here too. So, yeah, Liz. Yeah, let me get a microphone. We have one right here.
And I might as well stay.
But I don't, yeah.
Hello, thank
Hi.
you. Yes, and just reiterating Becky's comments, it's been a fabulous conference, so thanks to everybody. My name's Dr. Liz Curran. I'm from the United Kingdom, Nottinghamshire. Just a sort of observation, and it was picked up, it was a comment by Jenny Davidson from the University of Melbourne in Australia. And there's been a lot of discussion this week about people-centred justice, so thank you for that. And I think you've highlighted really important, something that is often and has gotten a little bit lost sometimes in the conversations this week. So I guess that's why I just want to reiterate a couple of things. So it's more a comment or just to make it doesn't get lost. Been a lot of people talking about justice as if it's about courts and tribunals. A lot of people talking about justice as if it's about access to legal services. And I thought, Your Honour, you made the point really beautifully that people-centred justice is about people. And when I'm an evaluator and a researcher and a practitioner, and I work with multidisciplinary practices, my background is I've worked with some of the most disadvantaged communities and different types of communities experiencing incredible trauma and lack of cultural safety. And I continue and will continue for the rest of my life until I'm in the grave doing that work. My view is that if you or anyone wants to look at people-centred justice, we, as you said, people of privilege, do not know what people-centred justice is. The only people who know what people-centred justice is are the people who are experiencing social inequality, poor health, poor living conditions, exclusion, multiple disadvantage, cascading, intersecting. The clients that I meet in my research, they don't have one legal problem. They have between 3 and 10. Right. They have very rarely ever had any contact with the legal system before leveraged through trusted intermediaries and health or allied health professionals. That's how they get to us. They don't trust lawyers. They hate the legal system. And as I was saying to someone earlier, one of my participants recently said, why would I engage with the legal system when all it does is F me over and F my family over? So these are the people. But what I would say is they actually know what a good outcome looks like. They know a good outcome isn't a success in a tribunal, because they might have success in a tribunal but be incredibly traumatised by the process. So I just plead everybody, when you're looking at what a good outcome looks like and how to develop questions and measures, ask the communities what the measures should be. What does a good outcome look like to you? And what are the things for you that would lead to that outcome? And you'll get answers like respect, not being judged, being listened to and heard. So I just want to say that everybody who said this week they're grappling with notions of people-centred justice, people-centred research, ask the people, co-design your research, check in with them, see if your questions are right, see if the services you're delivering are actually addressing that. The Pulse survey from the Law Foundation said that people who got legal help weren't getting the help with the issue they came to get help for. So there's a lot that we can work with. Please, I just appeal, ask community, they know the answers. So that's all. Sorry, it's a long comment.
I mean, no, but it's the big challenge, I think, for all of us. You started by talking about inclusiveness and how we get more diversity involved in this conversation. One of the things that's been troubling me is how we hear from the people directly. We have, certainly at the NAC, we have members who represent vulnerable groups who work in the community, who have that firsthand contact and knowledge, but that's still secondhand. So that's one of the things we're trying to think of, how you actually get those voices heard. And I think those voices are going to be the powerful ones. If we need inspiration to lead change and transformation, I think it'll be those voices that will inspire and that will allow us to make real change, not just tinker.
Great. I'll come back here with the microphone. Yeah, it's all good.
Thank you. I have a slightly tricky question. So for a member of, oh, sorry, my name's Chris. I'm from Australia. I'm a CEO of a community legal centre. Slightly tricky question for someone from the judiciary. It's a separation of powers question. And how the different roles contribute to the idea of access to justice. In Australia, we've seen the politicisation of things like human rights, particularly around refugees and asylum seekers. And on a state level, I live in Victoria, the expansion of things like police powers and bail laws, and therefore building of more prisons. And these things clearly impact the idea of access to justice for marginalised and vulnerable groups. One arm of the separation of powers is obviously having a negative impact. So my question is, does that mean the responsibility falls on the other two arms, so the executive and judiciary? Or what can we be doing to influencing the legislative around trying to control this idea of politicisation of human rights and access to justice? I hope that made sense.
I'm familiar enough with what's been happening in Australia to try and avoid that discussion. But I will say that, I mean, it's not really tricky in the sense that everybody has a role to play. When we talk about separation of powers, everybody has an important role to play in access to justice. No doubt about it, legislation will often define the kind of justice that you receive in any kind of formal adjudication. And the processes leading up to that, but they can set the standard of what justice has been defined as in a particular area. So the legislature, Parliament, for sure, gets to make those kinds of big policy decisions. In my experience, many of the problems are about the kinds of things that politicians have a lot less interest in: process, the way in which work is done, unless it costs money, in which case you have to make a real business case for it. I think there's a lot of room for the judiciary, for the legal profession, for community legal aid, for community organizations to make substantial progress. I must say that in Australia, just from the little reading I've done, separation of powers means something a little different than it does in Canada. In Canada, because we have the charter, we just decide according to what the charter asks us to decide. And in that case about immigration detention, more recently, separation of powers was used the other way, that legislature and executive couldn't impose punishment. That was, the courts could do it. So I found that very interesting, because usually separation of powers in Canada means that the court shouldn't get involved. And it's usually used when people don't like the way the court has gotten involved.
Thank you.
Maybe it was a tricky question after all.
Next on the line, I've got Paul from the World Bank.
Hi, I'm Paul Predator from the World Bank and from your neighbor to the south. But I have a question about you, for you, because you mentioned people-centered justice, which in the international development context where I work has become kind of a big focus and gained a lot of visibility. But when we talk about it, a lot of what's mentioned is about reform around the edges, doing what we already do a little bit better and maybe thinking about people when we redesign things. But I think there needs to be a much more dramatic rethinking of the way we deliver justice. And it could be how we educate the legal profession, who's part of the legal profession, and how we organize court systems. And I was particularly interested in your thinking on the latter. We have this kind of artificial separation between civil and criminal for many different reasons. And I noticed even in your National Action Commission is civil and family. In populations I work with, usually low-income, vulnerable people, particularly with family and criminal, there is a lot of overlap, and people have a single problem. That's a civil protection order, a custody case, and a criminal case, and trying to explain to someone why there's not just one case or all three cases will be coordinated is one of the most embarrassing things I've ever had to do as part of the legal profession. So I'd be interested in your thoughts about how the boundaries are really going to be pushed about how we organize ourselves. Thank you.
Now that's a tough question. I'm not sure I have an answer. I agree with you that there's so much overlap. And it's not just family and criminal, but the economic, the money cases are often about that kind of interpersonal or interrelational cases that have just gone bad. So there is no doubt overlap. I don't think we can get around the fact that in criminal law, there's a different burden. It's the state, and that there are protections that are built into our laws that don't apply in a civil or family matter. That said, to the extent that you're targeting the system, the court system or the tribunal system, and trying to improve processes, that the criminal processes could also be beneficiaries there. So I don't have anything more profound, I'm sorry, to contribute to that difficult question.
Daniel. I think you're up next.
I should have said because you're Royal Bank. I mean, and it's been mentioned here. Oh, World Bank, that, that of course, it's essential, a just rule of law, a stable justice system is essential to the economy as well, and to the way our standard of living.
We're really putting you in the hot seat today, aren't we?
It's okay. You can ask whatever you like. I don't promise to answer, but.
Totally fair. My name is Daniel Escott. I'm a research fellow with the Artificial Intelligence Risk and Regulation Lab. I'm also an LLM student at Osgoode, of all places. And
It means he's in good company.
So a lot of my work obviously focuses on the risks of using artificial intelligence, but specifically in the administration of justice. And that's kind of where my question originated, but there's been an interesting evolution over the last couple of days in the panel discussions and the questions back and forth on balancing innovation with the safeguards that have to be associated with the administration of justice and people-centered justice. And I would love to get your take on how do you balance innovation with constitutional or human rights needs in a way that's people-centered without sacrificing any kind of chilling effect on that innovation in the justice system?
Well, actually, I've often felt and reflected on that tension, especially, in the legal profession where, I mean, we're backward looking. We build on precedents. We count on a stability in continuity, and that's been reflected in our political journey as well. So you do need to have some stability. You do need to have some continuity. And maybe I speak, with the biases of someone kind of trained in the common law. An evolution feels much more comfortable to me than a revolution. And so I do think that you need to have a balance and attention and acknowledge them both. That said, I mean, we know that our systems are in crisis and they're not getting better, they're getting worse. We know that we can't just tinker, but that's not to say that you do it in a way that ignores some of the big ethical questions. What are the values that we have? So I think that provided you keep those things in mind, what are the values that underpin, why is the law important? And what is it what is justice? What are we trying to achieve? Then that gives you the foundations, the foundational stability in which I think you can actually have real change, have some significant change. I think AI specifically, I mean, anybody who thinks we can avoid it, I think it's coming, and it's coming in a big way. It's already here. So we are going to need to figure out how to use it to help us solve some of these problems while ensuring that we keep kind of the human judgment, the human value, the humanity that we need in the law. We've got to safeguard and preserve that. But I think, we're going to have to move cautiously, which I know is a word that's sometimes, an excuse. But I think in this case, especially with AI, that it's warranted.
I know we've got two questions over here. The Chief Justice, I think, has a quick comment that the Chief might make as well. So do you want to now, or do you want me to?
Yeah, no, go.
Sure.
Okay, so I absolutely agree with Justice Karakatsanis and her comments. I want to say that, unless we have a people-centered justice system, then we're going to have a crisis of confidence, right? Because if you're going to have access to justice, it can't just be built around us as professionals and lawyers, individuals who are using the system or administering the system. We have to consider the people who are users of the system. And I think that, you know, from what I've seen and, you know, over my years of practice, both in the courts and as a lawyer and as a judge, because of the lack of, you know, to some degree, emphasis on the users, some middle class individuals, like in family law, can't truly access justice, right? Because of, you know, the price or the cost of that access, the complications of the rules surrounding, and sometimes the technicalities of the applications of those rules, that we lose the common sense touch as to how, you know, average ordinary people relate and understand, you know, the whole system. So I think, you know, we need to be open to listening to the people that we're trying to serve in the system, or else we're going to be irrelevant to them. And if we're irrelevant, and, you know, we have to assume that most people have common sense. And sometimes, and I remember when I was in law school, there were rules that I thought and principles of law that evolved that I thought just did not apply to me, right? Because it just didn't make any common sense to me. And so I felt left out for all sorts of reasons. And so that's why we have to have, you know, a broader understanding of the complexity and the pluralistic nature and diverse nature of our society, so that we can, you know, as the law evolves, and I agree it shouldn't be a revolution, like the principles of our system is still the best, I think, out of most other, when you compare it to other legal systems. But I think that we have to, as we understand the complexities of different cultures and peoples, we have to be nimble enough to allow the law to evolve in that direction. I remember when I was a student, we didn't study Indigenous justice, or it wasn't really a part of our curriculum. We now have a much more fuller understanding of you know, restorative justice and its application within our common law system, and how beneficial that could be, right? I grew up as a Crown here in Toronto, as a Crown lawyer, and it's the restorative justice principles that in the 90s that eliminated a lot of the backlogs in the criminal courts. Because we had this Ascot case, and some of you may not have remembered that sort of grind the criminal courts to a halt. And as a Crown, I worked on a committee that was set up to streamline the justice system. And it's what we did was we incorporated restorative justice principles such as diversion, you know, a lot of you know, peace bonds and so forth, rethinking and reimagining the system so that we could focus more on the serious matters. And you know, years before, it wasn't a part of the way that, you know, the architects were thinking about the system. So I think, you know, that's an example of how the system can evolve once we start thinking about who do we need to build the system for, so they can truly access it, or else it's going to be irrelevant to them. If it's irrelevant to them, then the entire rule of law then becomes irrelevant. And we then have a crisis of confidence in the entire system. So those are my comments.
Thank you, Chief Justice. Susie, there were some questions over there, I think.
Yeah, no.
Oh, thank you. And one behind Noel too. I think,
Oh, there
yeah.
was, okay. No, do you have a microphone? Oh, thanks. Oh, thanks. Hi, my name's Elaine. I'm from South Australia. I am a recent master's graduate and early career lawyer. I'm also very nervous, so if I start rambling, please shoot me a look. I guess my question to you is is from my research and my experience in these kind of early years of practice. I didn't set out to practice law at all and have kind of just found myself in this space, in the access to justice space. And I guess I say that just to contextualize my shock at some of the practices that I've seen by lawyers, not necessarily in this access to justice space and people who actually care about vulnerable people, but as you know, the legal profession is kind of a larger thing. And I know that there's been kind of an evolution from zealous advocacy to this more person-centered lawyering, but it's not, you know, it's not sector-wide. It's not something that all practitioners even care about, is my understanding. And I have acted for people and advised people who I've been almost driven to tears by the respondent, like by the other lawyer, and I just like, it gives me chills to think about how they would treat someone who is self-represented. And so I guess my question is, you know, given the long history of and very entrenched principles of practice and our ethical and professional obligations that have, I would say, largely remained unmovable, like ideas of privilege and confidentiality, conflicts of interest, and how that's been translated into zealous advocacy and kind of weaponized. I wonder whether there's any, I guess I'm just thinking about your thoughts about whether there's any kind of scope for reform, or whether that's something that we need to wait to culturally change, because honestly, I'm not really optimistic about that.
So you guys all have some very difficult questions here you're asking.
Tell me when you're done.
Well, there's no doubt that the legal profession has a huge role to play in improving access to justice, and has a huge responsibility. And there's no doubt as well that the legal profession has, I mean, there's a lot of, I guess, there can be resistance to changing the way that things have been done. But I would say the legal organizations are very much aware of this. Civility has been a big part of the discussion of what the legal profession should aspire to in the last few years here. We have big professional organizations who are involved with us at the National Action Committee, who will be involved in trying to find new models, for example, new models of legal assistance. And I think that there is overall a desire to kind of think back on the profession as a profession, and one of a noble profession, and one that is where your duty is not just to your client, but to the system as a whole, to vulnerable people. And in our oath in Ontario, lawyers are required to swear that they will practice in a way to safeguard access to justice for all, or human rights for all. So there is the aspirational work that's going on. Pro bono has done great work in the last number of years. So there's a real sense, I think, within the profession that they have an important role to play, and that they can be part of the problem, and that they will be and want to be part of the solution. I think that's right.
Just Noel, before we come to you, just in line with Justice Karakatsanis' comment. This weekend, the Canadian Association of Legal Ethics is having its annual conference, similar kind of collaborative, really great group of scholars and practitioners and what have you. And it's gotten bigger. And your question and these themes will be very much explored, not just this year, but over the past number of years. I almost ditched this conference to go to see my friends there, but I didn't. Anyway, so it's a really important question.
Mhm.
Thank you. This has been a tremendous learning experience. Among other things, I learned that I've been mispronouncing Rhiniac versus Malden for the past 10 years of teaching.
Either that or else I have been.
Okay, I guess we'll never get to the bottom of that one. But one of the things that makes your CV really unique is your experience in the civil service. And it's often said that we kind of have a too many cooks in the kitchen problem with reforming our justice system, in the sense that we have judicial independence and judges control a lot of the ways that courts operate, but then we have attorneys general and the Department of Justice and so on. And never the twain shall meet, or they can't cooperate, or various versions of that problem. And I'm wondering if you see that as an impediment to justice reform in Canada, or if perhaps there's some examples you've come across of productive collaboration between elected branches and judicial branches when it comes to reform.
I guess I think we all have our role to play, and I think we have to respect that they're different roles. We're not elected, thankfully. We're not beholden to any particular constituency. We have judicial independence, and that's a really important aspect of our justice system. So that does create boundaries, if you will. And it's the same thing with the legislature. They're the ones who get to decide the big policy questions. But inevitably, there's overlap. And especially in an age with the charter, which requires us to apply values, really. They ask us to balance different values. And so I have certainly found understanding the way the other branches of government work and understanding the kinds of things that motivate them very helpful to me personally in my work. I have seen many examples of collaboration. The toughest thing is money. I mean, I've sat as cabinet secretary, I've sat around the cabinet table, and I'll tell you, in a debate between health and justice, or health or education and justice, or between a lot of things in justice, justice usually doesn't get the money unless it's for more police or more crowns or more, on the law enforcement side. And that's partly what I think this group and the work that you do can help with. I think there are real costs and benefits to justice, and the costs of not getting the system right. There's a real economic case to be made, I think, for the economy, as we've talked about. So I do think that with better data and with better research, we can make a better case for funding things that are important. And I'm not talking about more money necessarily to the courts. It may be more money to, I don't know, education. It might be more, there may be completely other kinds of initiatives that we've been talking about. But I think data and research are going to be key to making a case that'll help persuade the politicians that this should be a priority, because it's important to people, and because it makes economic sense and it makes political sense as well. Not sure if I answered your question really. To me, it's a system that basically works. It's people have talked about it as a dialogue. There's tension. There are times when, of course, you may prefer that the legislation said something different. There are quite a few of those times, actually, but that's not my role. And there's something comforting in knowing we each have a responsibility and an accountability, and to focus on doing that right.
Susie, before you come to John, can I think we're getting trumped. I just got an order. No, I'm kidding.
I should have just let you take that one right on. You're going to talk about the heads of court meetings every month.
That is my role,
Yeah.
right? to ensure that the courts are working efficiently, and that, you know, we as chief justices work collaboratively with the minister to ensure that the court is properly resourced, but at the same time, we stay within our lanes, right? And that cannot be done without conversation. And while the tension is on the outside, when we work together, I think we work collaboratively. And so I can tell you that, you know, over the last 2 years, we've had some very good, productive, you know, experiences with the government and our courts in Ontario. We were really challenged with resources for support staff in our courts. Those of you from Ontario, you would have seen this 2 years ago with a lot of court rooms being closed. But, you know, through collaborative, you know, conversations and negotiations, we've been able to get meaningful resources allocated so that staff can be hired with benefits so that we can then get that, right? And it's the same with respect to the federal government and the delays in judicial appointments. Without collaborative dialogue and work behind the scenes between the chiefs and the various ministers of justice, you know, we wouldn't be able to address these issues effectively. Because again, and like Justice Karakatsanis says, it's, you got to have a good business case, and you've got to be able to show that the data is for the best interest of business in the country and in the province. And if you don't have a solid, stable justice system, no one's going to want to invest in your society, right? Or in the province, for that matter, because people want to have, if they have disputes or conflicts, they want to be able to go to court, they want to be heard, and they want to be able to get these disputes resolved. And the same when it comes to, you know, victims of crime. They don't want to know that they're in an area doing business where, you know, crime is not under control, or there isn't accountability for people's behavior and conduct. And so I think we work, it's an integrated approach to ensuring that the system works effectively, and that in the real world anyway.
John, you got a question?
Maybe we'll end with, probably just given the timing, maybe this will be the last question, John, and you can keep it a good, quick one.
Absolutely. John Conn, I'm a PhD candidate at Osgoode Hall Law School. I'll start with my question, which is about legal data, and I'll end with an example of the kind of legal data I'm asking about. And it's really interesting to kind of hear the perspectives of both of you, but where and what do you think is a prime mover on generating better data about courts and judges? For example, I wrongly thought that your
Between courts and what?
Courts and judges. I wrongly thought, for example, that your court's decision in R and KGK, which was about judicial deliberation time and the lack of evidence on the record about that, would have motivated attorneys generals and courts and everybody to try to figure out that key question. Yet since your court's decision, we still don't really know the average time in judicial deliberation. So if you had all the money in the world or all the power, where would you dedicate your energy and resources?
I try not to think about what I'd do if I had all the money in the world and all the power. Make for a depressing alternative, eh? Do you know, I mean, I keep coming back to this because I don't have the answer. I keep coming back to, you have to start by knowing what it is that's important, what it is that we value, how we want, you know, what is it that we really want to accomplish at the end of the day, and then you work backwards. Then you figure out what the data is that you need. Now, basic data like timelines and the systems and the courts and the tribunals, I think that if they have, if it's available, that's something that should be easy to get. But my guess is if there's any resistance in getting that kind of data, it's because it's not readily available. And so, having been deputy at the time, we tried to bring in a wholesale integrated justice, automating things, which maybe didn't work out as well as we'd hoped. I would sometimes guess that the problem is not a willingness to provide data, but just not having it or not being able to readily access it. So there's a big challenge, I think, both in terms of conceptualizing what information you need, empowering, the institutions having the ability to gather and collect that data, and then being able to evaluate and answer it. So wish I had all the money and power. No, I don't. I don't actually.
What I would say on that is this, right? It's also dependent on the courts, right? So the provincial courts, their time for deliberation is much faster because it's a very different type of, it's more like a triage type court system. So most cases are going to be dealt with almost the same day, and the answer will be given immediately. For the superior courts and courts of appeal, if it's a jury trial, then we know exactly how long it's going to take to deliberate, because the case is going to be dealt with almost immediately after the jury.
And the judge is going to be up all night writing the jury instructions.
And we've experienced that for years, right? Like, I mean, you're up nights and, trying to write this, and you deal with it right away. Appellate court, it's more a deliberative type court. Certainly the Court of Appeals are a bit different from your court, but we have 6 months in most cases, 90% of the cases. What has happened, I think, over the last, let's say 15, 20 years is that there's been a lot more complexity in the cases that are being heard before us. And so while the majority of our cases are dealt with within that 3 to 6 month period, there are a few cases that takes longer because each judge is independent that's deliberating the case. And so we may have differences of opinion. And if we do, then we have to dig deeper into the law to persuade our colleagues that we're correct so it may take, I don't know, 6 to 9, sometimes 12 months, but those are the exceptions. What I can tell you is that in Ontario, we have the best data. To be quite frank with you, someone from Saskatchewan did this study on the various deliberative times.
You're talking about the Court of Appeal, right?
Court of Appeals, yes. Not superior courts. But I mean, the superior court's also the largest in the country. So, it's more complicated. But we certainly do. And I think that the Supreme Court, the cases that you hear,
we average 6 months.
Yeah.
And part of the complication for us is we have to have 2 official versions, one in English and one in French. And the jurilinguist job is very difficult. We have to approve both versions. And so that adds a bit of time, but our average is 6 months. Yeah.
Yeah, so sometimes the case might be finished in 4 months, but
often,
the procedural time that it takes to translate. Thanks.
I'm just asking Justice Karakatsanis if she has any last words before we wrap up.
I just wish I'd been here from the beginning. I wish I could have been. That's all.
Well, I do have a couple of final comments, but can I just start by thanking Justice Karakatsanis. We already thanked the Chief Justice, but I'll thank you again, Chief, for coming again. So I know people have to travel. You've got lots to do. I'll be pretty quick. I'm not going to do a full brief. So what did we learn over the course of the week? But I think we've learned a lot. But I think where I was reflecting a lot on what I'm hearing and what have you. And I think I really am going to end on a positive note. You know, I bet it's hard for some people, certainly for clients, and I can't stand in their shoes, and also for some of the people who have been working in this area for a long time. And I'm thinking about our clinic colleagues, right? Like the notion of people-centered justice, you know, in some of these conversations, it comes off as it's like this new topic where you talk to, you know, Lenny or Michelle or Mary or others who are working in the clinics, and Janet here. And I know there's others around the world online and here too. I can just see sometimes that, you know, we've been doing this stuff for a while, right? Like, please catch up. At the same time, I think there's been some real moving of the dial. And, you know, Paul from the World Bank, lots of work there. We've got colleagues from the OECD who are online, and this like huge energy, which maybe it's catching up, but it's actually making a difference. So that idea of top-down change and, sorry, bottom-up change, but also that idea of top-down change, the UN, SDG 16.3 just didn't exist before. And now it's a development goal. And so now we've got our colleagues, Catherine's here from the Department of Justice, like a whole new department and energy thinking through this idea from different, as Justice Karakatsanis says, the different partner roles in this crazy mess of justice that we're working on. So I really do see over the past number of years, massive amounts of new things, new voices, new energy, new institutions. And in this room as well, new partners, new players, new activity. So I really do think it's a moment of optimism. Whether we're changing people's lives, I still think is an open question. I know it's making a difference. We hear that from the research. I know our clinic colleagues hear it from their clients every day. And then finding a way to move that dial so that at the treasury table, justice doesn't continue to lose out and be a rounding error on big budgets, because we know that justice health is so important and will make such a difference when we think about the determinants of health and well-being. So all to say, I think it's worth what we're doing. We are making a difference. Obviously not me, but you guys are, everyone, all of us are making a difference. And I think it's terrific. I guess I'll close by just thanking people. I want to thank the folks who have done this conference before, who have forced us to bring it over to here to Osgoode. I'm really glad we did. I want to thank our OPD colleagues who have been carrying us through and nourishing us and videoing us and doing all the stuff that actually makes these things happen. I really want to thank my Osgoode colleagues, and in particular, Erica, who you've all worked with and over the course of the couple of days. Things are not self-executing. My colleagues, Trish and Susie, when we put this thing together, I don't think we had this sense of we really worried that we were going to be sitting here by ourselves, like, this is a good idea. Anyway, so, and I guess that really takes me to all of you. Thank you for hanging in there for the full 3 days, for making the effort to come to Toronto, for making the effort to be online. I just think it's been a great success. So with all of that, a big thank you to you guys. And at some point, there'll be a reveal of where this happens next year. So stay tuned and travel safely.